It's time now that we call the special meeting of the Palm Springs Administrative Appeals Board to order. At my request, Board Member Cleary has offered to lead us in the Pledge of Allegiance, so I would ask that we all stand.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, and with liberty and justice for all.
Thank you.
Thank you, Mr. Cleary. I'll now turn the floor over to the City Clerk for roll call.
Thank you. Board Member Cleary?
Present.
Board Member Kearns?
Present.
Vice Chair Howard?
Here.
Chair Reed?
Present.
All present. Thank you.
At this time, I propose a motion to adopt the agenda for this special meeting.
Mr. Chair, prior to your consideration of that motion, I want to place the board members on notice and the public who are here that rather than consider the 4 items that are on the agenda today, we'll only be considering 2 items because items 1A and 1D have been pulled by staff and my office, City Prosecutor's Office. We've managed to resolve those matters based upon circumstances of those 2 particular matters, which were related to home sharing, not vacation rental per se. The current ordinance distinguishes between vacation rentals and home shares, as you all know. Those 2 matters won't be considered here today.
Okay, thank you, sir. With that amendment to the current agenda, so that items 1A and 1.4 have, I'm sorry, 1A and I guess it'd be 1D have now been removed from the agenda. We'll proceed on items 1B and 1C. I move to approve the amended agenda. Do we have a second?
I'll second.
All those in favor?
Aye.
Aye.
Approved unanimously as presented with the withdrawal of items 1A and 1D.
Okay, ladies and gentlemen, with the acceptance of the agenda, we'll now proceed to general public comment before the board. I want to go over a few ground rules before we open public comment. First of all, the board generally cannot take action on items that are not listed on the agenda. Secondly, testimony for individual hearings will be had during those hearings. During the 2 hearings this morning, agenda items 1B and 1C, we will open public comment on each one of those hearings. Third, public comments will be limited to 3 minutes. The timer will indicate right in front of the microphone when your time is up by the illumination of the red light. To address the board, you will need to fill out a speaker card, which looks like this. The speaker cards will be presented up here, and I'll call in the order in which they're received. As the presiding officer, I'll call your name, you come to the microphone, and then you'll have the floor for 3 minutes to address the board. Okay, so at this time, I'll call the first member of the public who's registered to address the board. Mr. Owens, are you present? Mr.
I'm Mark Owens. I'm a resident of Palm Springs and a voter, and also a member of Protect Our Neighborhoods. People that are opposed or in favor of short-term vacation rentals keep saying, just let the ordinance work. Not only has the industry said that, owners, but also the City Council subcommittee. Our city manager actually said in an interview last month that some people in the city can't help make this ordinance fail.
Can you step a little closer to the microphone?
Usually I'm louder than this, so I didn't want
I know.
to, sorry about
Thank
that.
you.
So I've got a booming voice. So my point today is that I believe that the city is undermining this ordinance, and for a large part of the population that believes that it's illegal to start with and is wrong, that the things that we're doing here make this worse. How so? You have 2 cases now in front of you, and you've been given 4 options. Yet when I read the ordinance, you're not given any options. The option, it says under C, shall. If you're found guilty, you shall pay $5,000, and you shall be removed forever. So my question is to the city is how does shall become maybe? Or how does maybe become, we're going to try to negotiate something before it gets here. At the end of the day, this is a binary choice. It is guilty or not guilty. And if you're guilty, you're out. So my point would be here is for the integrity of this ordinance and to help those of us that don't agree with this in the first place, if found guilty, you must not acquit. Thank you.
Thank you, sir. Mr. Ziskin, are you in the audience? Good morning, sir.
Good morning, board members and staff. At your last board meeting, I asked, why are there exceptions and second chances which aren't allowed for in the ordinance? So today I ask, why is a code enforcement department adjudicating a written citation after it's written? To me, I'm not an attorney, it would be as if you got a traffic ticket and then the individual started complaining to the police officer and he decided to tear the ticket up or give you a lesser offense, when in fact, that ticket should be appealed in the proper manner to all of you. This disparate treatment appears to be becoming a pattern. It's nobody's fault. It's a fact of there are no written procedures. I know they're coming down the road, but since there are no written procedures, we appear to be in the Wild West. And this flies in the face of the strong enforcement that the City Council enacted. That's all. Thank you.
Thank you, sir. Before proceeding to the next comment, I did want to note that in the interim between the last set of hearings and the hearings we have today, the City of Palm Springs Vacation Rental Department, with the approval of the Assistant City Manager and the review of the City Attorney, has adopted a regulation. That regulation is available to those members of the public who'd like to review it today. After reviewing it, it may address some of the issues, sir, that you have raised.
Chairman Reed, I'd like to
Yes,
note just that the signature on the regulation is that of Assistant City Manager Marcus Fuller. I personally spoke with our city manager, Dr. David Reddy, and only per his authorization did Mr. Fuller execute that regulation.
Thank you for the clarification.
Thank you.
Okay. Next, Mr. Erkins, are you in the audience? Thank you, sir.
Good morning, and thank you. No one is above the ordinance, and what we discovered from our last meeting going on, we had 2 individuals that were stayed. They were given a process that was not in the ordinance. We did let them go back, and now they can become eligible for an STR when they should have been fined as an STR and also ineligible and $5,000. We have the same thing happen today. Thank you very much. You're changing it again on us. You're getting with David Reddy, and you just got this part that changes and says, amending that they can do what they want. These citations are citations, and it is put in place that it is not there. I didn't get a voice of appeal when a voice went against my appeal on a citation. I don't like the fact that now we're pooling 2. A deal was done on the back room on the 2 that were pooled. Home sharing does fall under the ordinance. I would ask that you as a board say bring it forward, because this is going to come up. It's going to continue to come up. It's going to water down your guys' negotiation skills. And also, I'd like to know the authority of you as a prosecutor and a city manager, city attorney, how this can go forward, that you can play 2 roles and then also claim that something goes to the California Supreme Court. Why do we not suggest to the people that now you've made ineligible and given a $5,000 fine, let them all sue the city like the people were not allowed permits that Kim Davis just did to the gays when she did not give them permits and gave each one $230,000, the judge did. I want to know why the process is the process. I want to know the administration. I want to know the back-end deal that went on the 2 of home sharing that's in the ordinance. It's not a $900 fee. It's a $225 or $75 fee. Home sharing is part of the ordinance. That's what you guys should ask. You should ask that it comes forward, and it should be represented here, and it should be put through the test. And if it's not put through the test or through the steam pot and everything, let it explode, because something else is going to explode at one point. And this is not fair to us residents, and you guys spent all this time, and you got it, and you got the information, and now we just let it go, and it's a waste of your time, and it's a waste of your time, and it's a waste of city payers' time. So why are we tracking them down? It's my next question, if we're just going to let home shares off. Thank you.
And sir, one issue I would like to address on behalf of the board is that, as with any other administrative body or court, we hear the cases that are brought before us, and there are obviously two parties in every case. If those parties represent that before the hearing occurs that they have resolved their differences, we then have no choice but to accept the fact that action has been withdrawn from our agenda. We have no jurisdiction to bring the parties before us and hear the case when they represent that they've resolved the issue. So I just want to clarify that.
Can I speak to that 1 second?
Yes, sir, even.
So what that means is transparency is not made to the residents, it's not made to the voters, it's not made to anyone. If a deal has been cut by Eddie and Dr. Reddy on the back end, then that's something that, again, I now understand your point, and if it's not before you, you can't request it. But then something illegally was done in my eyes as a resident. And this is an explanation that needs to come from them, and they should reinstate it and bring it forward. Because Documentations and Freedom of Information Act will request all that information to find out what went down and what's going down. There's something going down, and these should not be done, as Mike Zinsky said. We are not following our rules.
Okay, and that concludes the public comments for those individuals who filled out comment cards. Are there any other members of the public who wish to address the board on general issues at this time?
Mr.
Okay.
Chair, so as not to proceed out of order, I just want to note, because there are members of the public who are here, and there have been some significant aspersions cast during the public comment. I plan on responding to those comments during the city prosecutor reports and comments section of our meeting today, but I'm not going to proceed out of order. Suffice it to say for now that if you care about the truth, you'll stick around and hear the response.
Thank you, sir. Okay, we will now proceed with agenda item 1A. Agenda item 1A, before I open it, I'm sorry, 1B, 1A has been removed from the agenda. I did want to review, for those of you who will be presenting to the board during hearings, the order in which we'll proceed. We start with the City Compliance Department of the Vacation Rental Department presenting a report to the board. Following the report, the board members will have an obligation and an option to address the members of the City Compliance Department with any questions or requests for information. After that, the appellant, the individual who's challenging the city's action, will then have an opportunity to address the board. Appellants are given 10 minutes of time in which to address the board. Following that, members of the public who wish to address us on that particular case may do so. At that time, members of the board may then ask questions of the appellant, address any comments made by the public. At the end of that part of the hearing, the city will have an opportunity to present any rebuttal evidence on new issues that have been raised by either the appellant or the public. At the end of that time, the presentation of evidence will be closed and the matter will go before the board for public deliberation. During public deliberation, members of the public and appellants are not able to address the board. Once we have completed the acceptance of evidence, that's the end of our intake of evidence, either by documents or testimony. Okay, so at this time then we'll proceed with agenda item 1B. I do understand that the appellant is not present and is not going to be present today. So unlike other cases where the appellant would make a presentation, we have accepted a letter that was written by the appellant. When we get to that point in the hearing, I will give the board members a few minutes to re-review the letter before we proceed.
And Mr. Chair, the public should note that pursuant to the Brown Act, the materials received from the appellant are in fact available to the public, and they're next to the city clerk. I'll explain that process after Mr. Stark delivers his staff report.
Very good. Hey, sir, please proceed.
Thank you, Mr. Chairman and the board. Boris Stark, Vocational Compliance Official, City of Palm Springs. Mr. Jeffrey Upin has requested an appeal of, number 1, permanent ineligibility to operate a vacation rental in the City of Palm Springs, and 2, the administrative fine of $5,000 for operating an unregistered recreational property located at 1035 West Oakcrest Drive in the city of Palm Springs. The property located at 1035 West Oakcrest Drive, Palm Springs, has now been issued a vacational certificate by the city of Palm Springs as of date of the administrative citation, June 13th, 2017, or any time in the past. Staff has determined the owner has advertised and operated the property as a vacation rental. Advertisement of the property located at 1035 Oakcrest Drive, Palm Springs, California, was found on VRBO.com under the title of Sunrise East Townhouse, Palm Springs, California, under advertisement number 936727. Minimum stay, the advertisement stated the minimum stay is 14 nights. Page 2 of 15 of their advertisement, which states minimum stay 14 nights. Based on the advertisement information, administrative citation number B0013 in the amount of $5,000 was issued to Jeffrey Upin, who is the owner on title for operating a vacation rental without a vacation rental certificate. A corrective action plan was included to state the penalty of permanent eligibility to operate a vacation rental in the city of Palm Springs if completed by Mr. Upin, and if so, the $5,000 would have been paid accordingly. The administrative citation was mailed by staff via U.S. Postal Service and was received on June 14, 2017 to the person on title. On July 19, 2017, staff did a routine check on VRBO.com of the property located at 1035 West Oakcrest Drive. The property listing was advertised as a minimum stay of 30 nights now. The vacation rental compliance official, Boris Stark, and myself attempted to book the property online for less than 30 nights. Ms. Jody Upin responded to my inquiry and provided a quote for 12 nights and noted that if I wanted to book full 3 weeks, the townhouse is available in September as well. This was done on VRBO.com under the advertisement number 936727. Staff is noting that corrective action plan was not completed and the $5,000 citation fine has not been paid as of today with Mr. Upin's appeal. And I open it now to any questions from the board.
Mr. Chairman?
Okay.
Yes, sir.
Mr. Stark, what was the date of your interaction with the appellant, the online?
That date is July 19th, 2017.
July
19th.
That's last week, right?
That is correct.
And was that, and when was the citation issued?
Citation was issued on June 13th, 2017.
June 13th.
That is correct.
More than a month later.
So why was the, what was the objective in having that communication with the appellant?
The objective of that communication was, according to their appeal, that they would revert to a 30-day minimum, and the objective was to confirm what they have stated is actually true and, in fact, what they would be doing with their property. And unfortunately, the findings were not in line with what they were advertising during my interaction with her.
Well, the violation is with regard to events occurring on or before June 13th, correct?
That is correct.
So what is the relevance to us of anything that happened after June 13th?
Sure.
Mr. Vice Chair, I think I can assist. Rather than provide the exact answer Mr. Stark gave you, I think he'll interrupt me if I make a mistake. The nature of the contact subsequent to the citation date was further investigation by the city staff with respect to exactly what the circumstances were of the violation that is the subject of the citation. I think that staff probably, and I'm only speculating here, Mr. Stark will correct me if I'm wrong, wanted to provide the appeals board with the fullest amount of information, the greatest amount of information possible with respect to what might have gone on that date of the citation. In terms of the relevance of that and the significance of that, it's certainly the case that in any prosecution, how a person behaves after having committed a violation is relevant circumstantial evidence with respect to the events and the intent, if intent is in fact a relevant aspect of the offense that's alleged to have been committed. So again, this would be investigative activity undertaken by the staff subsequent to the violation. You're quite correct that if that's all they had, there would be no evidence of a violation. But I think staff is offering it to the board insofar as staff wants to supplement the picture of what it was able to gather vis-a-vis investigation up to and including the date of the violation.
What was the date that the advertisement was observed prior to June 13th?
The date of the advertisement was June 13th, 2017.
Okay, the citation was issued the same day.
That is correct.
The advertisement was deemed by the staff to be the operation consistent with the new
I
regulation.
understand.
Thank you.
Thank you.
Thank you. Mr. Stark, in addition to the evidence that you presented that there was advertising on or prior to June 13th, did you find any indication that individuals had actually rented and occupied the property for fewer than 28 days in exchange for payment to the appellant?
No, we didn't. We were not able to obtain any individuals who rented this particular property for less than 28 days.
Okay. Mr. Kearns or Mr. Cleary, do you have questions for the city?
So when you, on the 19th, when you checked to see if they would do it for less than the 28 days, you were basically just seeing if they were following what they promised us?
That is correct. I was following what their appeal stated and continuing our investigation into operation of this vacation rental.
In which case they did not follow.
That is correct. What they advertised was a 30-day minimum, and upon inquiry for less than 28 days on 2 occasions during our conversation, the property was offered to be booked, including a what you would call a quote or approval to book the property was sent via email by the owner of the property.
Okay, thank you.
Mr. Chairman?
Yes, Mr. Howard, please.
Well,
proceed.
What would you have done on July 19th had they said, oh, sorry, sir, we have a 30-day minimum?
What would I have done if they would have said we do have a 30-day minimum?
Right.
I would have further brought that into this packet as well for your meeting to show you that these people are honoring what their appeal statement does say to support it.
But the citation would stand.
I'm sorry?
The citation would stand.
That's not something that I could state.
The citation would stand.
Yes.
Yes, sir.
Yeah.
So again, if the homeowner's response on July 19th, whether it was you're welcome to come for 2 weeks or it's a 30-day minimum, it doesn't make any difference to the issue before this board. It's irrelevant. That's all I have.
Thank you. Mr. Cleary?
Thank you, Mr. Chair. I was just going to ask Mr. Stark, it appears that the property is owned by Jeffrey Upin, and he refers to his wife in his letter to the board, and his explanation is that he never received any notice from the city of any ordinance change. He's a resident, an out-of-state resident. Is it the policy of the city not to send a notice to homeowners that are suspected of being in violation, that there's an ordinance they're suspected of being in violation of? Is there he's complaining there was no notice. Is there a notice attempted?
Are you asking, was there administrative notice sent warning them that they may be in violation?
That's
what
what
you're
I meant to
asking?
say.
No, it was not sent. Actually, there's an administrative regulation dating back to 2000, I believe 12, that foregoes warnings in the case of vacation rentals. In this kind of a manner, we do not give warnings of violations. Instead, we proceed directly to the violation.
So ignorance of the law is no excuse in the city's eyes.
That is correct. If you own a property, and you should be aware of the local laws of the property where you're an established homeowner.
And they were here in December, January, and March for extended period of time, so they should have heard something somewhere.
Okay. All right. Thank you, Mr. Stark.
You're welcome.
Mr. Chair, not to interrupt the board, as soon as you're done, please allow me to address the written materials.
Are there any other questions from the board for the compliance officials?
No, thank you, Mr. Chair.
Okay, this time the chair recognizes the city attorney for comment.
Again, the city prosecutor in these proceedings, I appreciate the fact that I do have that function outside these meetings. With respect to Mr. Yupin's appeal, as I said, there are some written materials submitted. You'll recall that on the last hearing date, we had someone who did fly in from out of state, and that was appreciated to the extent that these proceedings are accorded the dignity that they in fact have by the people who are subject to them. But it's a situation where Mr. Yupin contacted the city, and he was looking for a reasonable manner in which he could proceed to pursue his appeal, while at the same time not spending the money on his airplane ticket. So, as the city prosecutor, I made a decision that provided we had a properly authenticated statement from Mr. Yupin, that we would allow it to be presented to you. So what we did to authenticate that statement is we had him send it via email, and also obviously in hard form in the original, in a notarized form. And we also had him telephonically verify the content of what was transmitted after the fact. So I'm comfortable, particularly as I explained to all of you last time pursuant to Chapter 2.50, that the rules of evidence don't all apply here in these proceedings, that there are different parameters for what comes in and what you all consider, that it's appropriate for you to consider Mr. Yupin's written narrative. He did provide it to you under penalty of perjury. As you see, we require that anyone who participates in these hearings render and tender any evidence that they have, again, under penalty of perjury, so that there's a guarantee with respect to its veracity by the person who's offering the evidence. And I didn't want you to accord Mr. Yupin's comments any less dignity or credibility than you would if he was here to make them himself. That said, I regard his declaration or his document, it's a de facto declaration because of the form in which it's submitted. I regard it as basically an admission of guilt, and I come to Mr. Howard's comment that on a certain level, the staff's investigative activity subsequent to the fact, although perhaps interesting and probative on a certain level, was not necessary, that the advertisement having taken place is in fact sufficient for the proof of the violation that the staff has alleged, and that the penalties that have been provided for and requested by the staff and by my office at this juncture are in fact the penalties that are before you. So I want to agree with the Vice Chair. I want to tell you that as far as I'm concerned as the city prosecutor, you have a basic admission of responsibility from the property owner in this case, and I think it's exceedingly straightforward.
Thank you, sir.
Thank you.
So at this time, in lieu of testimony, I want to give the board a few minutes to review Mr. Yupin's statement. Members of the public who wish to review the statement, it is available for you to review.
And for the record, it will become a part of the record of these proceedings.
Very good. We're going to go ahead and give the board 3 minutes to review the letter, unless the board requests additional time. Gentlemen, you all have a copy. Mr. Cleary, you have a copy?
Yes, thank you. I'm reviewing it now.
Thank you. proceed?
Yes, thank you.
Yes.
Very good. At this time, we will open the floor to public comment. Mr. Owens, are you present? Very good, sir.
Can I get the microphone thing right this time?
Thank you, sir.
I have two comments about this issue. I'm a little baffled about why we're even having a discussion about this. If we're going to spend this much time on unpermitted properties, it's going to be a real problem. We get suspensions. The permitting process has been in place since the fourth quarter of 2008. Nobody can say they didn't know about this. So on the face of it, he's guilty. I mean, that's just it. Secondly, I have a problem with the basic concept that we're now allowing people to not show up, submit stuff in writing. Mr. Kotkin said no a few weeks ago. If I were to appear in court for a traffic ticket, didn't show up, I'm guilty. So again, the process has to have some integrity, and I don't think this does at this point. So thank you.
Are there any other members of the public who wish to address the board on this agenda item 1B? Okay, very good. I'm closing public comment at this time, and we'll, because we have no further evidence being presented by the appellant other than the written statement, I will ask the city if, based on the written statement, they wish to present a rebuttal statement related to any issues that the appellant raised.
No, Mr. Chair, as I told you, we deem that document basically an acknowledgement of responsibility under the ordinance.
Okay, very good. So at this time, I will close agenda item 1B to the extent that we're presenting evidence to the board, and will now turn the matter over to the full board for public deliberations and decision. Thank you. Mr. Kearns, would you like to start the discussion?
After reading Mr. Uppin's response and his claiming not to know, I agree that there's no way he could not have known. A type of the policy has been in effect for almost 10 years now. Anybody would have any kind of knowledge, even if they've been only in town, especially when he claims that he was in town December, January, and then March. I know that it was all over the place all 3 of those months, because it was it's been a very hot issue for over a year now. So his claim that he doesn't know or didn't know about it, I can't find that to be all that viable. And as Mr. Kotkin and Mr. Boris have said, that they do not issue administrative warning notices. That is also what I've found to be fact, that they don't have to. There's nothing showing anywhere that it's required. And then with the addition to that, with them after them being fined and having well known by then, Mr. Boris still tried to see if they would rent it out for less than 30 days, which they said they would, and even offered him a better deal if he did it for 3 weeks instead of 2, or 12 days rather. That shows pretty much that they're not following what even they said they wanted to follow. So that's all I got.
Thank you, sir. Mr. Howard?
My view is that the evidence provided by the staff adequately establishes a violation of the ordinance, and that the information provided by the appellant fails to present any ground for finding otherwise. And my conclusion would be to deny the appeal and uphold the violation in both the penalty of the fine and the permanent ineligibility.
Thank you. Mr. Cleary?
Yes, thank you, Mr. Chair. My only comments refer to Mr. Uppin's letter. Obviously, the board wanted to give him an opportunity I mean, the point is for them to have a opportunity to be heard and receive notice to do so. So he's written a letter. In his letter, it appears to me that he indicates that his association where his residence is located prohibits rentals for less than 30 days, that they have not, he states that they have not rented out the townhome for less than 30 days. In contrast to Mr. Stark's subsequent investigation, Mr. Yupin claims that he had refused an offer to rent it for 2 weeks. So we do have a dispute as to whether or not he's engaged, but clearly the homeowner is denying that he's rented the home for less than 30 days. And in all the 10-year period that he's owned it, he's only rented it 4 times. And then discusses kind of equitable arguments about lack of notice and the fact that his property taxes, this exceeds what his yearly property taxes would be as far as the fine is concerned, in an attempt to at least mitigate if the board finds that he's in violation. But, you know, here you are in a quandary. You have a homeowner claiming that he did not violate the statute, and the evidence against him is zero direct evidence. There's no direct evidence. There's nobody that has walked up to the door and observed this being rented at the time. There's no witnesses from the association. There's no neighbors here to testify that this is in fact what occurred. All that is presented is hearsay evidence. Hearsay evidence in the form of a VRBO listing. And that's hearsay. Hearsay is a statement made out of the proceeding. A VRBO is not present in this room to tell us anything. So the statement from VRBO is made outside of this hearing at this, and is not made at this time. That's a hearsay statement. The rules under 2.50 indicate that it's a relaxed proceeding, that hearsay is admissible, that we can, conduct the hearings in a more relaxed manner and use evidence that a reasonable person would deem relevant in the conduct of their important personal affairs. However, the rule also states that we are prohibited from making a finding based on hearsay alone if it is subject to an objection and would not be admissible at a civil proceeding. That's what the rules state. We are prohibited from making a finding based on this evidence alone. Direct evidence is preferred. And the co-chair requested Mr. Stark indicate if there was any direct evidence of a violation, and he indicated no, there was no evidence of a rental during this time period. Based on the rule, what we are to consider, I think that there's a failure or a lack of evidence at this time. That's my comment.
Thank you, sir. Based on what I've reviewed, I look at the evidence that the city presented. There was an advertisement on June 13, 2017. I look at the appellant's letter where the appellant states, we advertised the townhome on VRBO. He basically admits in the second paragraph that he advertised for fewer than 14 days, and his intent was to solicit individuals to rent his home. And whether his actual intent was for greater than 28 days, he states in the second paragraph that he advertised for 14 days, and I think holding him to the advertisement that he placed on VRBO is appropriate. I also would note that it's my understanding that this case seems to fall, in terms of public policy, right into one of the major purposes for this ordinance, which is we have an individual who does not live in Palm Springs, in fact lives far away from Palm Springs, and is claiming ignorance of the ordinance when, as the gentleman noted, the ordinance has been in effect since at least 2008, requiring registration. And so given the context of the ordinance, the purpose of the ordinance, and also the evidence before us, I'm inclined to deny the appeal and uphold both of the city's remedies that were imposed. Is there any further comment from the board?
No, thank you, Mr. Chair.
Thank you. Okay, at this time, it'd be appropriate to call for a motion. Is one of you like to propose a motion?
Sure.
Mr. Kearns?
Motion that we do deny the appeal and that we uphold the administrative decision to permanently make him ineligible to operate a vacation rental, and uphold the administrative fine of the $5,000 that has been issued.
Is there a second?
Second.
Okay, Mr. Howard seconds. Okay, so there's a motion that has been brought before by Mr. Kearns and seconded by Mr. Howard. The motion is that the board deny the appeal of the administrative decision that Mr. Yupin is permanently ineligible to operate a vacation rental in the city of Palm Springs, and the administrative fine of $5,000 for operating an unregistered vacation rental for the property located at 1035 West Hillcrest Drive. Translated for the public, by this motion is proposing that we uphold both of the remedies that were imposed by the city in this case. All those in favor?
Aye.
Aye.
Aye. All those opposed?
Nay.
Any abstentions? Okay, the motion passes on a vote of 3-1.
And noting the no vote from Board Member Cleary. Thank you.
Thank you. Okay, at this time, we will proceed with agenda item 1C. This is an appeal of the administrative decision that Mr. Jonathan Clark Bender is permanently ineligible to operate a vacation rental in the city of Palm Springs, and the administrative fine of $5,000 for operating an unregistered vacation rental property located at 1020 East Christina Way. At this time, I will open the floor to the compliance representatives from the city to present a staff report.
Mr. Chair, before Ms. Severin delivers the staff report, this is an interesting situation, different from the others that we've dealt with up to now, and I want to explain a certain element factually of what's going on here. Mr. Stark actually had a life before he became a city employee. He didn't just materialize one day at City Hall. And in the course and scope of his prior life, he actually managed vacation rentals for a private company. In that capacity, he has some familiarity with Mr. Bender. And what I did not want to happen was for that interaction to in any way, shape, or form taint these proceedings. I did some thorough analysis yesterday of Mr. Stark's relationship with his employer and the relationship that that employer had with Mr. Bender. And I want to inform and advise the appeals board that I have no reservation about Mr. Stark sitting here and remaining. As you probably all know, in the context of government work, when there are financial conflicts of interest, we require government officials to recuse themselves. But so that these proceedings are in fact above and beyond reproach or any collateral attack with respect to the integrity of these proceedings, I wanted to make this comment in the unlikely event that the applicant, the appellant in this matter, would suggest or urge the board to infer that Mr. Stark's past life in any way impacted the enforcement action here. There is no financial conflict of interest, but in light of the fact that he did have that prior life, I have instructed him to refrain from participation in these proceedings so that even the appearance of impropriety, let alone any actual impropriety, not taint these proceedings. Ms. Severin will deliver the staff report, and I may have comments afterward.
Thank you. Thank you, Mr. Prosecutor. In light of the disclosure you just made, I would request also that either Ms. Severin or yourself address the issue of whether Mr. Stark had involvement in the investigation, findings, gathering evidence in this case that will lead to Ms. Severin's report.
No, I'll address that now. Mr. Stark did in fact sign one of the citations. I believe it's the final citation for the $5,000. But he did that in a ministerial capacity, and more importantly, it was not a violation of the conflict of interest laws that apply here in the state of California to official activity. I'll also tell you that as a practical matter, because I didn't know much about Mr. Stark's prior life, I just met him myself when I got hired. But now that I know that he had this specific responsibility on an ongoing basis, so that this issue doesn't even need to be discussed ever again, if there are vacation rentals with which his prior employer interacted, he won't be involved in any way, shape, or form in those investigations. So your question's a good one. It basically zeroes in on the city's desire to always be, again, above and beyond reproach, a million miles outside the specter of any appearance of impropriety.
Thank you.
Thank you.
Ms. Severn?
Thank you, Chair. Mr. Jonathan Clark Bender has requested an appeal of 1, the permanent ineligibility to operate a vacation rental in the city of Palm Springs, and 2, the administrative fine of $5,000 for operating an unregistered vacation rental property which is located at 1020 East Christina Way in Palm Springs. The property at 1020 East Christina Way, as noted, was managed previously by a local management company. That relationship ended, that business relationship ended in December 2015. The city has not issued a vacation rental permit directly to Mr. Bender for this property. Staff has determined that the owner has advertised and operated the property as a vacation rental. There were 2 prior administrative citations issued under the previous ordinance for the same violation that I'll speak to in a little bit. Let me go ahead and speak to the first prior citation, which was failure to register. It was an administrative citation that our office issued on December 27th, 2016. It was citation A1678. And the basis of that issuance was an advertisement of the property on VRBO on December 27th, advertising, and I quote, "Privacy and elegance in Central Palm Springs, cul-de-sac, new." The advertisement number is 30298, and the advertisement includes the following: a calendar last updated in December 2017, that's page 2 of 11. The advertisement states a minimum stay of 2 to 4 nights, and I've noted that there were 2 pages that said that. The owner has been a member of VRBO since 2003. The description of the property that is called About the Property states Perfect Palm Springs Vacation Home for short or extended stays. And there were 9 separate traveler reviews from guest stays during the months of February through September 2016. And in your staff report, I've quoted some of those reviews. Based on this advertisement, it was determined that the owner was operating a vacation rental without a certificate. That citation was issued to Mr. Bender, who is the owner on title. City records indicate the citation was sent via on-track delivery service to a 7208 La Presa Drive, Los Angeles address, and that was based on county records indicating the owner's mailing address at the time. On-track did confirm delivery on December 28th at 7:15 p.m. There was a second prior citation that we issued in January 25th, 2017. It was, again, a failure to register. It was based on continued advertising as noted in the staff report. Again, there was a calendar last updated January 24th, 2017. Minimum stay now said 2 nights. About the property continues to state Perfect Palm Springs Vacation Home for short or extended stays. And those 9 separate traveler reviews were on there, continued to be on there. Based on the advertisement, it was determined that the owner was continuing to operate a vacation rental, and we issued that citation number A1704. that was issued to Mr. Bender, owner on title. City records indicate that the citation was sent via on-track service to the La Presa Drive address. In this case, that package was returned to City Hall by on-track as undeliverable. Consignee has moved. So our office resent, in the interest of extreme cautiousness, we had no reason to believe that Mr. Bender hadn't received the first citation, but to be cautious and careful, we resent both citations on March 2nd, 2017. We sent a letter to Mr. Bender at the 1020 East Christina Way property address, since he was the owner on title. And we stated, we attached a copy of each citation, and we asked that those be paid by March 16, 2017. City records indicate that On-Track did deliver that. It was signed for by an individual, as noted in the staff report, on March 8th. Let's see. All right. So then that brings us to June 7th. June 7th, we issued a citation P0003. Advertisement at the property again was found on VRBO, the advertisement number 30298. The advertisement said the calendar was last dated on June 7th now. The minimum stay continued to be 2 nights. That was stated in 2 places in the ad. About the property, continued to advertise Perfect Palm Springs Vacation Home for short or extended stays. And in the rates and availability section, it states my standard rate, 2-night minimum, and a price of $275 nightly. And there are separate traveler reviews from guest stays during the months of January through April 2017. And those reviews do mention Mrs. Bender by name. Based on that advertisement, we did issue P0003. It was a $5,000 citation. It was issued to Mr. Bender, owner on title. City records indicate that this citation was sent to the Christina Way address. The package was returned to City Hall by On-Track as undeliverable, unable to obtain signature. Staff resent this citation and letter via Federal Express after doing some online research. We sent it to what we believed was Mr. Bender's work address in Washington, D.C. We sent that on June 14th. The package was delivered and signed for by a person noted in the staff report, and that was signed for on June 16th. On June 28th, I received a call from Mrs. Bender. She contacted our office stating that they had received the package, but they received it late because they were vacationing. We afforded the Benders additional time so that they could submit their appeal. And staff is noting that as of this date, the title report still indicates that the Benders own the subject property, and the citation amount of $5,000 has not yet been received. Thank you.
Thank you.
Did you receive a corrective action plan from the appellant?
We did not offer a corrective action plan because we considered this having 2 prior, Mr. Bender having 2 prior citations.
Okay. Secondly, I wanted to ask, can you give us some more detail about your staff's interactions with the Benders once they received the P0003 violation and contacted you? What was said? What did you discuss with them? What was the last communication you had?
So to the best of my knowledge, my staff did not have any contact with the Benders. As I stated, Mrs. Bender contacted me to acknowledge receipt and to ask for an extension because she said that she did not physically receive the package. Our conversation was brief. I listened to her. I wanted to afford her the opportunity for the appeal, so I did grant some additional days so that she would have 15 days from the date she stated she had received it. And to the best of my knowledge, again, I don't think anyone else in my department or our department had any contact with her. I notified the city clerk of the conversation after that they were planning to appeal.
I also wanted to ask, with respect to the offering of a corrective action plan to an appellant, can you describe better the city's practice? You mentioned that because there were 2 prior citations, a corrective action plan was not offered. If you could just review for the board, is it your practice that you only offer a corrective action plan to someone who has only 1 citation, and you offer it in relation to that citation, or what is the practice?
Well, you're beginning the discussion that I will try to initiate when I make my comments later today. But I'm happy to do that in the context of this appeal in light of Ms. Severin's comments. Whether to offer a corrective action plan is a discretionary matter within the office of the city prosecutor. And as a practical matter, that discretion is exercised on a case-by-case basis with respect to all of the facts of a particular case. I will note that in this particular case, since I'm being asked, the existence of the past history was the primary factor that weighed heavily in my judgment that no corrective action plan would be offered. But there's not going to be a regulation, there's not going to be an ordinance that documents how and when and why and where prosecutorial discretion is exercised. That's just not the nature of law enforcement.
Thank you.
Thank you.
Mr. Howard, do you have questions for the city?
No, I don't. Thank you.
Mr. Kearns?
No, I don't, thank you.
Mr. Cleary?
Just a few questions. Thank you, Mr. Chair. Ms. Severin?
Yes.
Good morning.
Good morning.
So we're talking about priors for these individuals, the Benders, and those are, it is true that they were cited twice prior to the instant citation. That's the subject matter of this appeal.
Correct.
And those citations were A1678 and A1704.
Correct.
And that was, it looks like December 31st or the 17th, I'm not sure, but 2016 for 1678 and January 15th, 2017 on 1704.
A1678 was December 27th, 2016, and A1704 was January 25th, 2017.
And those citations, however, they never did they pay those citations?
They did. We have not received payment.
Did those citations, those were sent to the address that was determined to be a bad address for these individuals, is that correct? The Prince Drive or Plaza Drive or Los Angeles?
Yes. When we sent the second violation, the first violation was signed for. The second violation we got was not delivered, and the on-track delivery person deemed it undeliverable. Someone, we heard that a neighbor had told them that the owner had moved.
Okay, so there's no service on the Benders on either of those 2 prior citations to indicate that they received them?
The first one they did.
Well, the first one was signed for by who?
I don't have that information, but I have, in your package, I have on-track delivery. We had requested that Mr. Bender sign for it. There is an on-track delivery receipt in there that shows when it was delivered. It doesn't show who it was delivered to.
Well, that seems to be kind of a failure of proof then, that Mr. Bender received that. You don't have any evidence Mr. Bender received that?
I don't, but I'd like to remind you that on March 2nd, we resent both citations to the Christina Way address, and those were signed for by an individual, and they were, that is the property at issue, and they are on title for that, and that was signed for. So we're reasonably assuming that that was received.
Okay. And that was part of the package that included the current citation?
On March 2nd, we resent both citations.
So the signing on the Christina Way of receipt was the 2 prior citations and the current citation. That's the subject matter of this appeal? No.
Only the 2 priors were resent. And then in June 7th of this year, we saw the advertisement again, and that was the basis of the P0003 citation for $5,000.
Okay, so, but there's been no resolution of the two prior citations were unadjudicated, they weren't resolved.
Correct.
Who did? Yeah, who's he? Yeah, I don't know.
Jonathan Clark.
Yeah, I don't know who those people are.
Jonathan Clark Bender.
Well, you're guessing.
That's his name.
Are there any further questions for the city?
Yes, thank you, Mr. Chair.
I'm sorry, Mr. Clerk, did you have further questions for the city?
I was just mentioning that in the packet on the on-track receipt, it does show delivery signature of Jonathan Clark. And going that his middle name is Clark, Jonathan Clark Bender, it can normally be assumed that that's probably him that signed for the December one.
And I just have one more question. Ms. Severin?
Yes.
They indicated that they were going to be in Palm Springs on July 24th. Isn't that this week in their letter?
I didn't make note of that as to this. Like I said, when I heard from Mrs. Bender, I granted additional days. I communicated that to the city clerk's office, and then I didn't have any other communication with the Benders.
Okay, that was a telephone conversation? And
Yes.
on July 3rd, when she sent a letter to, did you get the letter that she sent? On July
I
3rd?
received a copy of the letter from the clerk's office.
Did the clerk's office have any information regarding whether or not the Benders were planning to be present for the hearing?
Mr. Bender is here,
Okay. Great.
and he did speak, he did turn in a oath of testimony to speak later on.
Okay. No further questions.
Thank you.
Mr. Kearns or Mr. Howard, do you have any follow-up questions for the city?
No, thank you.
No, thank you.
Very good. So at this time, we will turn the floor over to the appellant. Mr. Bender, are you present? Yes, sir. Please come forward. So I'm not certain if you were present earlier when I went over the process. As the appellant, we afford you the courtesy of giving you 10 minutes as opposed to the 3 minutes we provide to the public, so you can give a full presentation to the board. I have before me your speaker card, which you have signed, and so when you're ready to proceed, please let me know.
Mr. Chair, before Mr. Bender begins, I want to make a comment, and I didn't make this comment today. I made it at the last hearing, and I told Mr. Yupin on the telephone, but I'm going to tell Mr. Bender so that there's no lack of communication. There's 4 bodies up there. I'm sure you count them as well as I do. In order to win this appeal, you're going to need 3 of them. A 2-2 tie vote does not amount to winning the appeal. If you wish to have this hearing continued, the city's perfectly happy to work with you on that, but I don't have a timeline for filling the 5th seat on the appeals board. I just wanted to tell you that in the interest of due process. That's it.
So, actually, to that, in the interest of due process, were I to want to extend this to when there is 5, am I also permitted to bring a lawyer?
You can bring an attorney if you wish to.
Okay. I mean, there are points of law being discussed here that, you know, in fairness to the appellants, that sometimes, you know, when points of law, I don't, you know, necessarily I'm not the best person to represent myself on matters of law. So, actually, I want to consider whether that is a wise course of action for me, because frankly, I guess what I've heard gives me pause. The fact that I haven't been notified. I don't know who Jonathan Clark is that signed.
Sir, before you proceed, I want to, so at this time, I think maybe what might be appropriate in light of the city prosecutor's comments, and the city prosecutor is referring to the actual procedures of this board that indicate a tie vote, in fact, would be a denial of the appeal. And we, as he noted, we do have an open fifth position to fill on this board as soon as a candidate comes up. But what I'm getting to is before you present any more information to the board, it may be appropriate to take a short recess for you to consider what the city prosecutor had mentioned. The board can take a short break, and we'll come back from recess, and you can let us know. That will also give you an opportunity if you wanted to confer with someone regarding that option you have.
Any indication of when a fifth member might be appointed?
I said very clearly, I have no timeline for when a fifth board member will be appointed. That doesn't mean it couldn't happen next week. It also doesn't mean that it will happen during the next several months. We do what we can to fill these positions.
It is an open advertised position on the city's website indicating that we are looking for a fifth member. And the city accepts applications from members of the public who are interested in filling that position. They vet those applicants, and the city council would interview and then appoint the fifth board member.
Believe it or not, these four gentlemen are volunteering to be here.
No, that's great, but I think, you know, having a full board is actually, you know, appropriate to applicants like myself, so.
Okay.
Well, you're entitled, and that's why I say what I said, because if you wish to postpone this matter, you had the right to have this heard here today. We can't take that right away from you. I wanted to make sure that we afforded you the due process to which you're entitled. Now you have a decision to make, and whether you want to make it now or after a break is up to you.
Thank you for that, and thank you, Mr. Reed, for that suggestion. I'm happy to have a break.
Okay. At this time, I'll move that the board stand in recess for 10 minutes, and that we return at 10 minutes to 10. Is there a second?
Second.
All those in favor?
Aye.
Okay, the board stands in recess until 10 minutes to 10.
If we can. Get one next week, or we could get
and the recess of the special meeting of the Palm Springs Administrative Appeals Board is now over. The board is back in session. At this time, we'll call Mr. Bender forward, please. And Mr. Bender, we would ask if you had ample opportunity to consider the options that we discussed prior to the recess, and if you're prepared to let us know whether you're going to proceed or request a continuance.
Ample is probably a stretch, but I am going to ask for a continuance because of that.
Well, in light of that decision, we'll need to pick a date certain at this time unless you want to leave it open and have it be a not to occur after certain date. I will say for the board's edification what I said earlier, which is you're not entitled to have 5 board members. So at some point in time, this hearing is going to occur, even if we have trouble getting a 5th board member. The flip side is that we'd love to have a 5th board member, and we will continue seeking to fill that position. So do you want to pick a date certain, or do you want to come back sometime no later than X date?
Well, first of all, it's less about the 5th member than it is about the potential to permanently disbar me from operating a rental in Palm Springs. That's a very serious. We have worked with rental agencies in Palm Springs for many years. You know, we're you know, happy to comply with city ordinances and a well-regulated rental market, but it feels like, you know, we have not received any of the notifications. I don't know who Jonathan Clark is, but that's not me, and I didn't sign that.
Sir, that's right. At this time, I have to say, you're starting to discuss with the board and present to the board substantive information. So at this time, what we really need to know is, you can talk to the...
I asked you a question. Do you want a date certain, or do you want to set a date not after? And I will note, for the record and for your edification, you've known for quite some time that this violation has the potential to make you permanently ineligible. From the moment you saw that citation, you've known that, and I think it's...
I've known that since I received it on June 24th of this year, sir.
Your statement speaks for itself. You've known since June 24th.
When I received, yes.
Okay, let's stick with that.
Okay,
in any case...
Gentlemen, at this time, rather than getting into the substance...
Not later than is the answer to the question.
Not later than.
Okay.
I will need to look at my calendar, and who can I talk to in your office to schedule a time?
If you want to schedule a time to communicate with the city regarding this matter, reach out to the city clerk. What we're going to do
is that Ms. Hart?
That's Ms. Hart. We're going to set a date that is acceptable to the board and acceptable to the staff to come back and conclude these proceedings, either with or without a 5th board member.
That's fine.
Staff, do you have any requests with respect to the timeline here?
With very few exceptions, I'm available.
So would it be reasonable to say no later than the end of August? Or do you want to push it out further?
It needs to be further for me.
Give me a date. Let's go without. No later than?
No later than the end of August is satisfactory to me.
Okay. Is that okay for the board?
I don't think we've set a date for another hearing set, so maybe we can table this for now, and when we pick a new date for any hearings, Mr. Chair, we could perhaps dovetail the two.
We can do it that way if that's the board's pleasure. There are no hearings at this moment actually set. That provides a certain lack of certainty that I'm less than comfortable with respect to the conclusion of this appeal, which is already midstream. Please understand that the city has videotape of what's happened up to now. That videotape, if we do, in the unlikely event, seat a 5th board member before the next hearing, that videotape will be available to that board member. And from my vantage point, I'm just looking for certainty. I don't care what you decide, I just want a decision. If the board's pleasure is to bring this back with the next round of appeals, that's what we'll do.
Mr. Chairman?
Yes, Mr. Howard.
I have some concern with the ground of the if there is to be a continuance here, apparently based solely on the fact of a vacancy on the board. Some of these boards and commissions go with vacancies for a long period of time. And I appreciate the possibility of limiting it to a date certain. That does give us some control, but I have some concern beyond the scope of this case that if that becomes an established criterion for an appellant to put off the hearing of their appeal and to allow them to remain in violation, potentially in violation of the ordinance for a period of time not contemplated by the ordinance, I think we may be perhaps establishing a precedent or an expectation on the part of appellants and members of the community that the ordinance is to some extent being rendered ineffective by lack of enforcement based simply on the fact that this is right now a 4-member board rather than a 5-member board. Certainly, I suppose our procedures allow for control of our calendar, the setting of hearings, reasonably to accommodate the needs of the staff and the board and the appellants. And so if we're almost at the 1st of August, if the staff and the appellant were to come to some agreement that this hearing could be continued to be heard by the end of August, I suppose that is a tolerable outcome. But I want this comment to be noted that I think it potentially presents a basis of abuse and exacerbation of various violations of the ordinance that might be noted.
And Mr. Chair, as the city prosecutor, I'm sorry.
Yes, sir, please.
As the city prosecutor, I want to concur with Vice Chair Howard. We made the comment we did out of concern for due process, and I did that to ensure the integrity of this prosecution, these proceedings before the appeals board. Then the appellant made some comments that it's really not even about the 5th board member. It's about the permanent ineligibility. It's not my decision, but the board can refuse to grant the continuance if it wants to. As a practical matter, we're here. We're in the middle of proceedings right now. Staff has presented its evidence. There's been board discussion. The appellant's here. He had notice. It's not the notice perhaps that he would have wanted, but he had notice. And in fact, the staff has taken considerable steps to accommodate the appellant with respect to the timing of these proceedings. So Mr. Howard's comments are appropriate, and that is why I did not want to leave these proceedings without either a date certain or a not to occur after date, because I don't want to see this process and this appeals board manipulated or taken for granted. I'm going to make sure that in addition to all of the notices we provide for future appeals board hearings, that we tell our appellants that there's only 4 board members if we haven't yet filled that 5th seat, and that no continuance will be granted on that date, but that as a practical matter, they need to get 3 votes out of 4. And the only reason that I'm affording that due process today, as I did last time, is that notification wasn't in the citation. We have to be fair, but I concur with Chair Howard. This ordinance is to be enforced. That is the direction of the City Council, and that is certainly my intent in these proceedings. So I would appreciate it if we come back before the end of August, if that is in fact what the board wants to do. If the board wants to, it's within its rights to insist that we proceed today.
Thank you, sir.
May I speak?
I was going to say, in fairness to Mr. Bender, there was an offer that was communicated to him before the recess. And as you noted, sir, that this is new information to him. It was not provided before this day. And we gave him an opportunity to consider his options. He has determined that he wants to exercise an option to continue. I think the only issue before the board right now, in fairness to Mr. Bender, is how long would the continuance take place? Would we want to give him the 30-day continuance, approximately 30 days that the city has requested? And Mr. Bender, you can address if you want additional time, tell us at this time, and we'll consider both requests and then come to a conclusion.
First, I'd like to address Mr. Howard's point and just put him at ease that, and I think Ms. Severin will verify, that the listing has been taken down, the properties, there is, no further violation happening, so just to put you at ease about that. Second, I would say that I would suggest, maybe for the convenience of you all, that at the next meeting of the appeals board that that we appear the next time you guys regularly are scheduled to meet. August, I think, is a difficult month for people with schedules and travel and vacations. So 30 days, I would suggest, is kind of tight. So I'd ask for a not later than, the next time the appeals board meets.
I do have a couple of comments myself.
Mr. Kearns, I was going to say, we have a request from the city, we have a request from the appellant. I would propose that we consider a middle ground, which would be that we could say that the continuance would be no greater than 60 days. However, if this board is scheduled to meet either for a special or regular meeting, well, I guess it would be a special meeting to hear cases, prior to the 60 days, that we would send the requisite notice to Mr. Bender that his case would be heard on that date.
I'm more apt to agree with both Mr. Conkin and the city staff members for the 30 days, more towards the fact that because I do reside here in Palm Springs, but my permanent job does at times take me out of sometimes in the entire state for periods of time, and it makes it hard for me to schedule a time to come back if I don't have at least a 30-day notice to come back. Right now, I'm scheduled here throughout the end of August, unless that changes. And if I do get sent elsewhere towards the end of August, it may not be until October before I could be back here.
Mr. Cleary, do you have any questions or comments regarding the continuance?
No.
Okay. Mr. Howard?
I have no additional comments.
This time I'll call for a motion on the appellant's request for continuance. Is there a motion? Okay, I'll move then that based on the input from the board, the input from the city, and the request of the appellant, that we continue this matter until the end of August. And I say that we can select a date certain within the last 5 days of the month of August to reschedule this hearing and proceed on this case. The city clerk would be requested that she coordinate that date certain with the board and also with the appellant and the city, but it would be for a date not to exceed the last date of August of 2017. Is there a second to the motion?
Could I ask for clarification?
Certainly. So the motion would be that the hearing we would call a special meeting of the Administrative Appeals Board before the last day of August of 2017, and that we would ask the city clerk to work with the board, the city, and the appellant to schedule that date during the last 5 days of the month of August, but not to exceed the last date of August 2017.
All right, well, I would just observe that's not a date certain at all, and it seems to me a pretty difficult task putting on the city clerk to somehow make that happen with input from the four of us, staff, and Mr. Bender. It might be a worthy objective. I don't know how possible it is, but...
May I add a little something? How about within the last 5 days of August, or as soon as practical? And that would give us a couple of days wiggle room into September.
There's a holiday at the beginning of September, and as soon as practicable becomes impracticable. And I'm just suggesting that we're all here now and that we seek whatever degree of certainty that we can. And
that is why I asked for a date certain.
I have any of the 28th, 29th, 30th, and 31st of August available. Any of those days.
I would propose, if we're going to select a date certain, that we give consideration to the city that they don't normally provide services on Fridays, so we try to select a date other than September 1st during that week.
How about August 28th?
What day of the week?
Monday?
Okay, the city seems to concur. Mr. Cleary, are you available on Monday the 28th, starting at 8:30 a.m.?
Yes.
And Mr. Kearns?
Yes.
Mr. Howard?
Yes. I would just observe, though, that the likelihood of a fifth member sitting on this board by August 28th is
near zero.
It's not going to happen.
It will not happen.
It is not going to happen.
I would also suggest, if I may, that I've had no visibility to the on-track signatures that are referenced. I think I need a little more time to review the evidence that
That's
they
not
have.
factually accurate, Mr. Chair. The materials are online on the city's website.
The on-track signature, my supposed signature from on-track is online?
There's
Sir,
never been a reference to a signature.
Okay, so at this time, I want to take us back to what brought us to where we are right now, which is the city prosecutor had noted that you have a right to have a hearing before 5 board members, and that if you were to proceed today and we have a tie vote, that in fact the appeal would be denied.
Well,
so,
and
I'm sorry,
apologize.
I shouldn't say right.
Correct.
Correct. That we were going to give you the option of having an appeal hearing before 5 members. In light of the fact that input from the city clerk and also from the city prosecutor is that it would be unlikely that the 5th board member would be appointed and prepared to hear appeals by the end of August, since that was the issue that was initially raised that led us to where we are now, I would propose, again, that we extend the continuance to the end of September. We set a date certain. If Mr. Kearns is out during the month of September, I suggest maybe the first week of October when he's returned to the Valley, and we set a date certain that all of us agree to. It seems consistent with the issue that was initially raised and brought us to this point. And again, in fairness, this is the first time the appellant is hearing about this issue, and so I'm trying to take that into consideration and proceed accordingly.
Is that a motion, Mr. Chair?
So that's my position at this time. I wanted to try and bring us back to the focus of why we are having this discussion.
That is appropriate. I did hear and note that the appellant said this request for a continuance was not about the fact that there wasn't a 5th board member.
It's part of it.
Right.
Well, I agree with Mr. Chair with your comments. I think in practical speaking, in view of the possibility of filling a vacancy, and in view of the fact that Mr. Bender would like some additional time, we have discretion under the rule to grant a continuance even during the middle of the hearing, if it would be in fairness to any side. So I think that in fairness, it should be accommodated. And agree with the time deadline. It's more realistic to go into September, October than to try to squeeze it into the last week of August.
So I have, at this time, unless there are further board member comments, are there any other comments? I'm going to propose a motion that we continue this hearing to Monday, October 2nd at 8:30 a.m. where we would, I'm sorry, Mr. Kearns, are you going to be in town then?
No, I won't be back until the 18th of October.
Oh, okay, so we have them. And what time are you, or what date are you leaving the Valley?
I am leaving September 2nd.
Okay.
Mr. Chairman,
Yes, sir, Mr. Howard.
is another comment in order at this point?
Yes, sir.
My head is spinning here on what if we're dealing with the 4-member issue or some other issue. If it's the 4-member issue, it's unlikely that a 5th member is going to be here even by October. It's very unlikely. But even if it were, what we're hearing is that there may be another board member who's out of town, cannot attend the hearing. The 4-member issue is something that we all are subject to at any time, whether there are 5 people on the board or 4 people on the board. So I think it's just a circular exercise in futility to try to lock down whatever advantage anyone may perceive in presenting an appeal to a 5-member versus a 4-member board. Those circumstances occur throughout government in various forums, different multi-member courts or governing bodies, and it's just dealt with as a matter of course and within the law. We do have discretion, as everyone has observed, and we're trying to reach some accommodation here, but it's the almost impossibility of that, I think, is becoming apparent as the discussion continues.
Thank you, sir. In light of 2 facts, number one, which is with Mr. Kearns confirming that he will not be available during the month of September and into the month of October, and if we were to schedule a hearing during that time period, we run the risk of not meeting quorum, given that any one of the 3 of us who remain may not be available. And given what I'm perceiving as the discomfort by the board of allowing this continuance to go past October 1st, I'm going to renew my motion to reschedule the hearing to Monday, Monday, August 28th at 8:30 a.m.
I'll second that motion. Yes.
All those in favor?
Aye.
Aye.
Aye. All those opposed? Any abstentions? Mr. Cleary, I'm sorry, I didn't record your vote.
I voted yes.
You did. Thank you, sir. Okay. The board unanimously continues this hearing until Monday, August 28th at 8:30 a.m. where we'll reconvene. I wanted to ask the city clerk, in terms of reconvening for a special meeting, at that time, will we reconvene at City Hall or will we still be here in the Primrose C room in the convention center?
I don't think anyone can answer that conclusively.
Okay. So notice to be provided at a later date identifying the place of the special meeting?
Correct.
Okay.
Thank you,
sir.
Okay, thank you. With the continuance then, agenda item 1C has now been completed. We will move now to the next agenda item, which is board member comments and requests. Mr. Cleary, are there any comments or requests you have we'd like to discuss, either regarding the procedures that we discussed in the last session or any other issue?
I just would state that we had 4 scheduled hearings, I think, for today. We were able to deal with 2 this morning with breaks and commentary. I would think that 2 to 3 in a morning session, and if there was more than that, 2 to 3 in an afternoon session would be the maximum. That would seem to be able to be handled by the board with questions and comments from the public to allow the homeowner and the staff and board members to comment. I just think that that number is more appropriate than the previous hearing, where I think we had 7 scheduled, and it was pretty tiring. So that's my only comment.
Thank you. Mr. Kearns?
I have nothing at this time.
Mr. Howard?
Nothing, thank you.
Thank you. I wanted to address the city clerk. The board wanted confirmation that the administrative procedures that we considered during our last meeting were actually adopted. We believe that we unanimously approved the procedures in the last draft that we reviewed, but we wanted to confirm that with the city clerk that they have been approved. They haven't appeared yet on the website. We were wondering if there was any additional amendments or comments that we needed to address.
No, they were adopted, as you stated. I am still working on the table of contents. Okay. I apologize. I have this other job.
Yes, you do.
In addition to this one, and I'm just not going to make excuses. I have not had time to come back to this. But now that the city council is in recess, I should have that completed and online within the next week.
Thank you, we appreciate it. We just wanted to clarify and make sure there was no further action needed from the board.
None, thank you.
Thank you. Mr. City Prosecutor, there were 2 issues I wanted to raise. One is the administrative regulations that were recently adopted. We wanted to give you an opportunity to inform the board about the process that the city uses to adopt such regulations, and in particular, why this was adopted and what the city hoped to achieve by adopting these regulations.
Sure. I think that's a great question, Mr. Chair. The ordinance, that is ordinance number 1918, that controls pretty much everything that our vacation rental staff does with respect to regulating this area, is a very, very fine document. It's also not perfect. There are some changes that are going to be forthcoming during the month of September. Clarifications, eliminations of conflicts with respect to verbiage in the ordinance and intent of the city council in adopting the ordinance. And as a practical matter, the city's, I think, done a yeoman's job, as the city prosecutor, anyway, I can say this, of getting on top of something that was a major issue of local concern. Now, that doesn't mean that it's a static thing, in fact, just the opposite. There are stakeholder meetings that go on all the time. There is an ad hoc subcommittee. There's, I believe, a standing subcommittee as well. And I can tell the board that these regulations were contemplated specifically by the ordinance as an exercise of the city manager's discretion in an effort to clarify the ordinance where clarification seemed appropriate. Well, we had our first hearings before the appeals board quite recently, as you all know, and the staff had been defining operation of a vacation rental as being perfectly satisfied by the advertisement of that vacation rental. And they explained to the board the many substantive reasons that in this particular area of regulated activity, that advertisement, particularly on the internet, is an extremely central, focal element of operation of a vacation rental. And there was a little bit of discomfort on the board because there was no definition of operation that was going to provide the certainty the board was looking for in performing its adjudicative role. So the city staff took that to heart, and we wanted to demonstrate to the board a certain sensitivity to that perspective. So we wanted to put that definition out there in the community before the board, and now it is. I spoke with Dr. Reddy yesterday and reviewed the regulation with him telephonically. He said he was comfortable having Assistant City Manager Fuller execute that regulation on his behalf as his designee. And then I spoke to Mr. Fuller, and he was also comfortable signing the document on behalf of Dr. Reddy as his designee under the ordinance. So we now have a clarification of operation, which is not as good as it being in the ordinance. So we're going to put it in the ordinance where it belongs. Now, certain things that the vacation rental staff does don't rise to the level of needing to be in the ordinance. However, they're helpful for the people who operate vacation rentals. They're helpful for the people who want to enforce our ordinance with respect to vacation rentals. And everybody's got an interest in seeing that this ordinance is worded clearly and implemented in a very fair and predictable manner. And that's important to the city as well. So these regulations are propounded. I think they're all online. Is that right, staff?
They will be.
They will be all online. I think that some of them already are.
Yes, they are.
This one I don't think may be yet,
Not yet.
because it was adopted yesterday. But as a practical matter, the city always undertakes to make sure that anyone interested in this area has access to full information. That's part of our responsibility. I hope that answers your question.
Thank you. Do any members of the board have questions for the city prosecutor regarding the new regulations?
Just one suggestion, that maybe we might add something in there about the continuances, maybe like a time frame that the longest they can be continued for.
Well, my response to that is that's entirely within the purview of this board. Realistically speaking, I think it was Member Cleary was saying you do have that discretion. As I commented, you could have denied that continuance if you wanted to.
Mm-hmm.
But realistically speaking, I'm not sure that our regulation in that area will be helpful. If you tell me that it will, then I'll speak with the city manager about it and we'll try to formulate something.
And if you want to address continuances, the other thing we do have our administrative procedures that are specific to our board that address continuances, and rather than address that in the vacation rental ordinance, we could consider amending our own procedures because we have that right.
I just don't want to see something where it might be like a 4 or 6 or 8 month continuance of something because of certain reasons. And
well, I heard Vice Chair Howard make
like
some
Howard
astute
was
comments
mentioning,
about, making the ordinance ineffective. We don't want to do that. So if you'd like, what I can do as the prosecutor for this board is I can speak with the chair after this meeting, and we can present to you when we come back on Mr. Bender's appeal on the 28th, we can present an amendment to your administrative procedures dealing with continuances. Would that be satisfactory?
Mr. Chairman?
Yes, sir, Mr. Howard.
I think, I just want to make sure we're observing a distinction here between the rules of procedure that we addressed at the last meeting, which was 20 or so pages, constitute the rules of procedure by which this board conducts its business. That's one issue. The regulation that was just adopted is a different issue. Those aren't the same thing. So when we say regulation, we're talking about specific substantive provision adopted by the staff under the authority of the ordinance. I think the issue of continuances is appropriate to be addressed within our rules of procedure rather than as a substantive matter within the ordinance or some regulation under the ordinance. And I don't recall whether in the procedures that we've already adopted, whether the issue of continuance of hearings is addressed. You're indicating it's not?
I do not believe so.
Okay. I don't recall, but if it's not, then I think that would be the appropriate place to address it. And then the question is, what are we going to say about it?
You're perfectly entitled under the Brown Act to give direction to staff at this time. So if you want to have a discussion about that, that's entirely appropriate. That said, nothing will happen today. In other words, we'll come back next time with the proposed amendment to your procedures, if that's your wish. That's what I tried to say before, and I apologize if I wasn't clear.
Well, I would just suggest for the consideration of my fellow board members that I think the principles have all been recognized in the discussion we had on the Bender case today. That is, we want to, when it's reasonable, make accommodations to have these proceedings occur within the convenience of the staff, our members, and the appellants. Yet we don't want that willingness to be abused in order to prolong a violation or facilitate continued violations. So I think it's just a matter of finding a way to state that flexibility is reserved to our discretion, but the intent is to resolve these issues on their merits in an expeditious manner in order to give effect to the intent of the ordinance. And perhaps there are other, if other boards and commissions have adopted any rules of procedure, perhaps that wheel has already been invented somewhere else that would be effective for us to use as well.
What I would propose is that during our next special meeting, if we add to the agenda as item 1A, discussion of procedures. And I would propose that we discuss two items. One would be the issue of continuances, and we could consider proposed language that would be provided to board members at least a week prior to the meeting for consideration. The second issue that we had discussed with the city prosecutor was some type of guidance or tightening on notice to appellants about the submission of documents to the board to avoid any confusion and submission of large volumes of documents during the hearing, which doesn't serve us or the appellant. So I would propose we would consider both of those issues on an agenda item so that members of the public are aware that we're going to consider that, and we can also receive comment.
Yes, we can do that for you, if that's the board's wish. I'm seeing affirmative nods and glances.
Mr. Cleary?
Yes. Okay. The second issue, Mr. Prosecutor, that I wanted to address was that there were comments by the public earlier that addressed certain issues. I think it would be appropriate for you to respond. If you're prepared at this time, we want to give you the floor to respond.
You know, it's something that happens in public meetings, members of the Board of Appeals, that because we afford the opportunity to anybody who wishes to make a comment to do so, that things are said that may be reasonably subject to discussion, may be outright false. And as a practical matter, I wanted to address a couple of things. With regard to the matters that were pulled off of this agenda, I think it's more than appropriate for the board to inquire, well, why'd that happen? And in fact, even if you hadn't done that, we have a way of doing things here in accord with state law that I don't get to speak about whatever I want whenever I want. Now's the time when I speak about what's happened. So yes, there were two matters that were pulled off of your agenda because, as I said earlier, our vacation rental ordinance is not perfect. And it's extremely important to me as the city prosecutor, where the truth and the facts and the ordinance itself are really all that drive my bus, that we have the integrity to stand before you and say to you, this person is responsible for his or her conduct under the ordinance. When we say that, I want that to mean something to you. Credibility is important. I heard someone say that this is a ministerial board today. Wrong. This is an adjudicative body. You guys are as close to a judge as anyone is going to see in the municipal process. So for someone to say that you're a rubber stamp, or because the words of the ordinance say what they say and staff issues a citation, you have to affirm that, that's nonsense. This is an adjudicative board. This is a country, this is a state, and this is certainly a city where we give everyone due process of law. So you're not a rubber stamp, you're not a ministerial body. And as strong an ordinance as this is, and as harsh as I am instructed to be as the city prosecutor by the city council with respect to its enforcement, we have to follow the law. And the definition of vacation rental as it is contained in the ordinance is something that is not subject to reasonable interpretation, in my opinion, where reasonable minds can differ. The definition of vacation rental says, and I'm reading the last 5 words, and does not include home sharing. Now, I know that this ordinance was intended to address home sharing harshly and strongly and aggressively. Unfortunately, I really like my bar card, and I'm really attached to the integrity with which I've tried to practice law these last 25 years. I think that may have been why the city council hired me. And as a practical matter, when I stand before you and I bring you a vacation rental case, and I tell you this vacation rental case should result in permanent ineligibility and a $5,000 fine, I need credibility and I need integrity. And if I'm telling you that someone who was operating a home share should be subject to that penalty, which applies to vacation rental without a certificate, guess what? Doesn't pass the mirror test, doesn't pass any test. So sometimes, as the city prosecutor, it's my job to say, you know what? I'm not going to tell you what you want to hear. I'm going to tell you the truth. And the truth is that if we want to address home sharing under the ordinance, we have provisions that do that. So I contacted the appellants in these 2 appeals, and I negotiated a disposition with each of them whereby they admitted the violation of the ordinance that they had perpetrated. They admitted that. They agreed to be subject to a corrective action plan that actually gives us more teeth than we would have had in a vacuum, and we did collect a fine from them. And no, it wasn't the $5,000 fine. And no, they are not permanently ineligible to operate a home share. But we now have each of those property owners on a fairly tight leash. And as a practical matter, the ordinance will be amended by the City Council. I've already discussed this without breaching attorney-client privilege and giving you inside baseball. I've already discussed this with the City Council subcommittee. They're aware of the issue. Our City Council doesn't want me as the city prosecutor to show up here and prosecute people who are not factually responsible under the ordinance because of a drafting issue. That's not who the 5 people that serve this city are. So that's why those matters were taken off the agenda. In fact, I'll go one better. One of the appeals that we already dealt with last week was a similar situation. I fully intend to go back to that appellant and rectify the situation with respect to the proceedings that took place here, because until they saw the appeal from the appellant, they had no idea that there was a home share as opposed to a vacation rental. So we will handle that matter in an appropriate fashion and likely be bringing corrective action to you in that case on August the 28th. Again, we need that credibility. If we don't have that credibility when we tell people you're permanently ineligible and make your check for $5,000 out to the city of Palm Springs, they're not going to have any reason to respect those statements. I think this board, in its actions, in its deliberations up to now, to an individual, all four of you, fully appreciate and understand that when this board makes a determination, that's it. If they disagree with the determination of this board, they can go to Superior Court. And at that point, we will stand up and we will defend this ordinance, and we will say, these individuals violated this ordinance. They were entitled to due process. They received due process under the ordinance. There was an issue about backroom deals. There's no such thing in Palm Springs. There's no such thing in any responsible city or government agency even. That doesn't happen. If I'm asked a question as to prosecutorial discretion, as I was today, I'm happy to explain myself. You guys are effectively the judge. You asked me a question, Mr. Chairman. I told you what the primary grounds upon which I exercised discretion was. Now, realistically speaking, I'll tell you, lots of prosecutors would not have answered that question. But I have no reason, as a city prosecutor enforcing these types of ordinances, to refrain from that level of transparency. Frankly, that's more than what the law requires. If you asked Mr. Hestrin, why did you plead this particular homicide as a first-degree murder versus this homicide as a vehicular manslaughter versus this homicide as an involuntary manslaughter, Mr. Hestrin is going to say, because I'm the district attorney of Riverside County and that's what I was elected to do, make those decisions. Prosecutors exercise discretion every day, all day. I work with the city staff to enforce this ordinance. The city council is fully aware and apprised of all of my actions. And as a practical matter, that's it. That's what we do. We prosecute these violations, we cite them, and we can't say that people who are cited aren't entitled to a hearing. This is the United States, this is California, and this is, most important to me, the city of Palm Springs. This is a great community where people have the right to stand up and disagree with an exercise of government authority if they want to do that. That's what this appeals board is about. I know the four of you get that, but it disturbed me when comments were made that may be televised to the contrary. I think that's enough. In the immortal words of Forrest Gump, that's all I have to say about that.
Thank you, Mr. Kotkin. Before we close board member comments and requests, are there any other matters that the board members would like to bring forward or discuss? Mr. Cleary?
Regarding the regulation that was proffered, the new regulation that's signed that's supposed to govern or be in addition to, I think the board struggled with the definition of operating a vacation rental at the last hearing, and this additional regulation was provided to help define or give guidance to the board in determining what operation means. In regard to that, there's an intent element that's specifically referenced in the regulation, and the intent is whether an individual intends to operate or lease or provide for a short-term rental of 28 days or less. That's what the intent element is. If an individual is guilty of intending to offer or lease for 28 days or less, that's what the focus is for the board to determine, and that's what specifically referenced in the new regulation. And there's an intent element now provided that I think is good guidance for the board in determining violations. And with that, I just want to commend the staff for their reports today and Mr. Kotkin for his advocacy. I believe that he's doing an excellent job in referring these cases to the board and providing the board with all the necessary information and guidance needed to fulfill our commitment to the city to provide a platform for individuals who want to raise appeals. And so I commend staff and the city attorney for their hard work. Thank you.
Thank you. Mr. Kearns, any further matters?
Nothing. Thank you, sir.
Thank you. Mr. Howard?
No, thank you.
Thank you. Before we close this agenda item, I just wanted to thank the employees of the city who are here today. They're accommodating the board's request to meet on a Friday. They may not normally be scheduled to be in the office, although I know most of you are so hardworking, you do come into the office on Friday. But thank you for accommodating our request to meet on a Friday. Okay, at this time, I move to the next agenda item, which is the city clerk's reports and future meeting dates. Any issues to address before the board?
I don't have any issues to address the board, just so that you know, as of this moment, we only have 2 hearings, and we will not be scheduling them until the homeowners will be returned from vacation. They have waived the 45-day hearing requirement. One of them will not be back until November, the other one, I believe, in September sometime.
And
Thank
Mr.
you.
Chair, I neglected to cover the one listed item on the agenda regarding disposition reports. The city staff did, in compliance with Chapter 2.50 of our code, file a report to the City Council. That report will be received and filed formally by the City Council at its September meeting, but by filing with the City Clerk, they have filed their report with the City Council. The City Council is just not available until September the 6th to receive that report. That report will ultimately be amended, as I'm going to note on August 28th for you, with respect to that one matter where we're going to have to take corrective action on the home share. And we will similarly be filing a disposition report as to these proceedings with the City Council. So again, to suggest that anything is less than 100% transparent, I don't know where that's coming from.
Was that report seen by this board?
No, it's filed with the City Council. The board filed it through the staff, and it will be available to you anytime you want. It's a public record right now. I could have it emailed to all of you.
I asked at the last meeting whether that report would be presented at least to our chairman for acknowledgement, approval, amendment, whatever.
And we didn't do that.
Prior to filing.
That's an oversight. We can do that with respect to the report of these proceedings. And if there's any amendment to the report that's necessary based on the chair's review, we'll make that revision.
I think that's essential.
Thank you.
Thank you. I will note that I did receive a copy of the report this morning at the time when I signed the resolutions regarding the adjudications from the last hearing. But I agree with Mr. Howard that I would request that I receive a copy of a draft report before it's finalized from these proceedings and going forward.
I agree with Vice Chair Howard. That is essential. It's a good idea.
Thank you. Okay. Sir, I did close public comment. Any comment you have?
Comment on the last case, even though we put in against it and you're putting it forward?
Well, it was continued, so when the case is called on the 28th, we'll definitely open it up to public comment. And if you attend on the 28th, you'll also be invited.
I might not be here, so that was fine. And I wanted to ask one other thing. If he's addressing certain stuff that has been brought up, can I go through you to address the proper ordinance number that shows proof on something that does fall under the Brown Act under my right?
So again, I would say the next time this board convenes for a special meeting, which looks like it will be August 28th, if not sooner, I will open for general public comment. You are more than welcome to prepare comments, attend, and provide those, or to communicate your comments to a representative who might present them on your behalf, or to attend another regular or special meeting of this board when we have public comment that's open.
And Mr. Chair, if the gentleman wishes to have any commentary on Mr. Bender's appeal considered by the board, all he's got to do is send that commentary to the city clerk, and it'll be provided and considered by the appeals board at the time when the appeal is taken up again. He's also free to obviously come back on the 28th if he's able.
Correct. Okay. This time, there are no further matters to come before the board. I'm going to move that the board adjourn until the next special meeting, which at this time is scheduled for August 28th at 8:30 a.m. Place to be determined in a notice to be provided to the public and to the board. Is there a second?
Second.
Okay, all those in favor?
Aye.
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 Okay, with unanimous approval, this board stands adjourned until the next special meeting on August 28th or sooner. Thank you.